right now, the audio video can be picked up on the audio and video recording. All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CV19-0065, Peralta versus Peralta. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your arguments. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal should you desire. Also, we have read the briefs. We have discussed this case in conference. We are familiar with the facts of your case. Take that into consideration as you make your presentation. At this point, counsel, you may proceed.
Good morning. May it please the court. My name is Dan Beeks. I represent the appellant, Roberto Peralta, who's here at the council table this morning. We're here this morning on our appeal of a judgment, a decree following a dissolution proceeding and the denial of a motion for new trial. Like many cases involving pro se litigants, this case was somewhat messy. There was multiple hearings in front of multiple judges. There was multiple post-trial motions, multiple rulings, multiple transcripts. So feel free to ask questions because I understand it's a little bit confusing trying to follow along.
You have multiple arguments. Let's start with what you believe is your most persuasive argument.
Well, I think our most important and probably persuasive argument is dealing with the custody, the legal decision-making and parenting time of the party's child, Aurelie. Aurelie was about 3 years old when this case was filed. She's started kindergarten now. The major issue at the time of trial and the major issue on appeal has to do with the allocation of legal decision-making for Aurelie and parenting time for Aurelie. Primarily, the issue deals with domestic violence and the effect of ARS Section 25-403.03.
And did the court find that both parties had engaged in domestic violence and that there was a significant history as to each?
It found that both parties had engaged in significant domestic violence against each other. You are correct. It's our position, however, and as you're, I'm sure, aware, subsection D of 403.03 says if there is what I'll call mutual domestic violence as a shorthand term, the presumption doesn't apply. I'll acknowledge the court did make that finding. It's our position that the trial court was in error in making that finding because mother had not raised that issue in the pretrial statement. As you know, Rule 76 requires a detailed statement of the disputed issues of fact and law to be presented at trial, and the Leathers versus Leathers case says that any issue that is not raised in the pretrial statement is waived at the time of trial.
But hadn't that issue already been fleshed out pretty much in the preceding hearing?
The issue had been raised at the initial temporary orders hearing. I don't dispute that, but I think it's important to go back and look at the Leathers case on that. What the Leathers case said is the fact that an issue was raised at a prior phase of the litigation at the temporary orders hearing, because that is exactly what happened in the Leathers case. You probably read the case that dealt with an insurance policy. The issue about the insurance policy had been brought up at temporary orders, but wasn't in the pretrial statement. The trial court found it's waived.
Does it make any difference that there was actually evidence taken on the domestic violence issues in those preceding hearings as opposed to simply raising an argument as to the existence of an insurance policy?
The way I read Leathers, it doesn't, and there's that unpublished Greenberg case, whatever it was, that we cited in our brief from last year. It's a memorandum decision, we understand the limited persuasiveness of that said even if testimony is presented, if it's not in the pretrial statement, it's waived.
What's the purpose of Leathers? It's isn't it counsel to prevent unfair surprise? How was your client unfairly surprised?
My client came to trial thinking he was only putting on evidence of mother's domestic violence. There was nothing raised in the pretrial statement that says anything about the mutual domestic violence exception, I'll call it. That wasn't raised as a legal issue. And there was no factual issues raised about mother committed domestic violence.
Did he make that surprise known to the court?
Did he object, saying it's not in the pretrial statement? No.
He did not. And when we go on, the court specifically said that evidence of father's domestic violence was relevant because both sides were claiming to be victims of domestic violence. So the court did put father on notice that that was a consideration, did it not?
Put it on notice. I mean, I'm not sure where you're reading from. You're reading from the decree?
I'm reading from the transcript of the testimony.
Oh, okay. At the trial, yes. But, I mean, by that point, we're in trial. He's already showed up. It wasn't raised as an issue. He didn't come prepared to talk about that issue.
But he didn't address that with the court by objecting or explaining to the court that that was not in the pretrial statement.
He did not make a Leathers objection, I'll call it, at the time of trial. I'm not going to say he did, because he didn't. But I don't think you're required to do that. I don't think Leathers requires it. It says if it's not in the pretrial statement, it's waived. So.
But and I apologize, maybe I missed this. In prior hearings, didn't the court find there had been domestic violence, mutual domestic violence?
No, the temporary orders hearing, they found mother had committed domestic violence, gave father sole legal decision making, gave father primary parenting time based on those findings. And then when we get to trial, then it's free for all, and everybody's pointing at everybody else, and the trial court made the findings it did to define the mutual domestic violence. But it's our general position that it shouldn't have gone there because the issue was waived. So
when we talk about issues of domestic violence,
sure.
You would agree that that's different than the issues that were presented in Leathers?
Oh,
Domestic
I mean,
violence is...
different than an insurance policy. I'm not...
And you believe that the court should just simply ignore mutual domestic violence if it's not put in the pretrial statement?
Or if it is going to be put in the pretrial statement, when it's raised in a motion for a new trial, I think you've got to go back and grant them a new trial and have somebody on notice allowing them to put the evidence on.
When we talk about the findings the court is required to make regarding best interest, how is a court to simply ignore evidence of mutual domestic violence, even if it wasn't in the pretrial statement, when making the findings required thereunder?
Well, I guess I'm not clear exactly what you're talking about. If you're talking about what we'll call the 403 factors, domestic violence isn't particularly a factor under there. Domestic violence becomes a separate factor under 403.03. So the trial court should do the standard 403 analysis, who's the child bonded to, which are the other family members and other important people he's bonded to. Those types of issues should still be considered. I get it. The trial court's going to be troubled sitting there hearing evidence about domestic violence on both sides, but the rules are rules. If you don't raise it in your pretrial statement, we're here today saying my client is held to the same standard as a lawyer. Well, we ought to hold the lawyers to the same standard the lawyers are held to too. And if you don't raise it in your pretrial statement, it ought to be considered waived. But that's our primary issue. The other issue that goes to the parenting time and the legal decision making of my client's child dealt with the lack of a reasonable amount of time for the trial in this case. As you probably recall, this case was originally set with the agreement of both parties' lawyers and the judge for a 2-day trial. My client's attorney withdrew shortly before that trial, and on its own, with no motion by either side and with no explanation, the trial court then shortened it down to 1 day.
Well, I thought the court explained that the reason it was being shortened was because it had already heard evidence on the domestic violence issue, at least as it related to wife, and therefore didn't need to take that time.
It had heard a bunch of evidence. It had heard the first temporary orders hearing back in 2016, and then it had heard another temporary orders hearing right after my client's attorney withdrew in 2017. So you're correct. They had heard a bunch of evidence leading up to that.
And husband, the way I'm recalling the transcript, husband was cautioned at several times during the hearing as to the judicious use of his time and that he needed to, if he wished to testify, and his testimony did seem to be important to the court, that he should take that into account rather than calling these other witnesses to talk about evidence that was already in the record.
The trial court, you're right, did caution him on a handful of occasions. The problem, as you probably also recall in this case, was there was some confusion because of this temporary orders hearing that had been taking place a few months earlier in November of 2017. My client shows up to trial, and the trial court said, hey, I'm not going to rule today because I'm just going to push everything off to trial. Shows up, none of the exhibits are there. Nobody had filed new pretrial statements. It was certainly reasonable for my client to understand that exhibits were going to be there from the prior hearing. They're not. There's a big kerfuffle. Mother's counsel, they have a recess. She goes back across the street to get her exhibits from her office. All that time gets charged to my client, and he ends up with even less time than the shortened one day we had at that point. Yes, like a lot of pro ses, he did not use the most efficient use of his time, but it became very clear, you can see based on the judge's questions, that there was very important evidence, i.e. my client's testimony, that wasn't going to be heard. Although Volk v. Brahms does say that, trial court has some broad discretion in setting trial time deadlines, and it doesn't have to indulge every inefficient use of time. It also says if it becomes apparent that the previously set deadlines aren't going to cut it, you have to be flexible. And especially in a case like this, where you're dealing with best interests of a child, then you get to the Hayes v. Gama analysis saying, hey, you don't punish the kids by not considering evidence regarding their best interests because of their parents' poor behavior. And I think by extension, by their poor ability to try the case. When you're dealing with a child's best interest, if it's clear that you're not going to get important testimony from an important witness, the trial court ought to consider extending the trial time. In this case, the judge, as you said, cautioned, hey, your testimony is going to be important. He knew it was important. When it became clear that they weren't going to get to it, the trial court should have continued the trial so they could have got that important information and made interest based on the best interest of the child, not keeping a tight calendar, not punishing father for not being a lawyer, not being trained. So it's our position, having raised that issue in a motion for new trial, it should have been granted so that the court could get father's side of the story, get the full information, and make best interest findings regarding the child based on a complete picture.
And was there anything you'd characterize as an offer of proof that was made to the court as to, Judge, if I had an additional 20 minutes, this is the nature of the evidence I would present?
As you would expect, a pro se litigant wouldn't even know what the words offer of proof meant, did not make an offer of proof. But I think the analysis in Hayes v. Gama is very telling. You don't punish them for not saying offer of proof. You don't punish them for not being a good trial lawyer when the best interests of a child are at stake, and the trial judge has made it clear on the record that he understands he's not getting a complete set of the story.
So this may or may not seem inconsistent, but you're arguing that mothers should be punished for waiving something by not having a pretrial statement, but that father should be excused for not managing his time properly.
It is somewhat inconsistent.
So let's go back and answer my question. When
Sure.
we talk about this mutual domestic violence and we talk about applying Gama to it, you want the court to ignore testimony that domestic violence was perpetrated by both parents and that has a direct bearing on the best interest of the child, whether it's in there or not. It deals with bonding, deals with all of the factors that you laid out. Why should the court ignore relevant testimony in that circumstance? I understand it's not in the pretrial statement.
Right.
I understand your Leathers argument,
Right.
but
And I understand your concerns. I think what the true answer is the court should have done what the statute basically requires. He used what I'll call mutual domestic violence as a way to sidestep the whole issue. You just say mutual domestic violence, and then you don't go through all of the factors you would otherwise go through for either party in analyzing under 403.03. Subsection E, there's all of the factors that you would normally be required to analyze as to whether a party has rebutted the presumption. That's what the trial court probably should have done under your hypothetical. But in this case, the trial court didn't make any of those findings. It just said there's mutual domestic violence, nobody's really a threat to the child, and I'm going to give joint 50-50 parenting time. So I've got a little time left. There's a whole slew of issues dealing with the attribution of income for purposes of child support. Briefly, the guidelines require two factors before income is attributed. Number one, it has to be a decrease of income as a matter of choice, and number two, not for good cause. The trial court only found that there was not good cause, or reasonable cause is the actual language in the guideline. The court did not make any findings that the decrease in my client's income was as a matter of choice. As you know, the decrease in income was because he got fired or got terminated from the Border Patrol after he recanted his accusation against wife on one of the incidents of domestic violence. That was not, as a matter of choice, it shouldn't have been attributed. Even if attribution was proper, the judge pulled the number out of thin air. There was once again, nothing about attribution was in the pretrial, and if you look at the transcript, there was absolutely no evidence about attribution at the time of trial. Attribution of income wasn't even raised until Mother started her closing argument. So the judge decided that my client could earn half of what he'd earned as a Border Patrol agent based on no testimony, no evidence whatsoever. That's called speculation. That's not evidence. That's not a proper basis for a judgment.
Except there was some testimony about his qualifications.
There was testimony at the time of trial that he'd been 21 years in the military. He'd served 10 years as the infantry, 10 years in explosives. So there was no testimony that he could earn any income as a civilian in the Yuma area anywhere near what he'd been earning at the Border Patrol. In fact, the evidence was quite to the contrary. As you may recall, Mother, as a result of some of these domestic violence allegations, especially the one where she was alleged to have pulled a gun on Father, had been terminated from the Border Patrol. And Mother testified, having been terminated from the Border Patrol, especially in Yuma, was a huge obstacle to finding employment. So there was no real evidence that my client could find that kind of income. And then there's the whole argument about whether the supplemental pay of $2,600 was still being earned. If you look at the exhibits, even in 2016, that number wasn't being earned. The judge just ignored exhibits that showed that money was not still being earned at the time of the trial, or even in 2016 when the case was filed. Certainly wasn't being earned in 2017 when he was terminated. You've got to recall, at that point, he'd switched from basically being a line officer, doing border inspections, apprehensions, and the likes, to being a union representative. Being a union representative, that kind of supplemental pay was no longer nearly as available to him, and he was down to earning like $600 a month rather than $2,600 a month. We raised that all in our motion for new trial. No evidence to support the judge's finding. The attribution was improper, and it ought to be reversed on that. There's several other issues in our brief. I'm sure you've read them. I'd like to reserve what little time I've got left to answer what's probably going to be some more questions.
Thank
Thanks.
you, counsel.
Good morning, Your
morning.
Honors. My name is Alan Cook. I represent the appellant, who on the brief is Bertha Alicia Peralta, but she uses Mizama now. Apropos of nothing whatever, I'm one of the people who would like to abolish the family law rules and just go back to the civil rules, which I thought were just fine. And part of the problem that you have with relying on appellate precedent is sometimes you have cases that are wonderful with the facts saying if it's not in a pretrial statement, you can't consider it. And then you have cases like this, where the best interest of the child are paramount. And I think that if there's any black letter law in family law, that's it. Cases involving children, best interest of the children are paramount.
Even if, in your view, that trumps the concept of notice in a due process construct. I mean, part of the purpose of a pretrial statement is to provide notice to the parties as to the issues to be considered and the evidence that needs to be brought and addressed at the time of the hearing or trial.
I understand.
Yeah. So is it your position that the fact that the issue of domestic violence had been litigated, certainly to some extent in these prior hearings, was sufficient notice?
Well, there was notice in that sense. There was also the fact that husband listed it as an issue in his pretrial statement, although he was saying that only wife had done it. I think certainly whether or not wife is the only person who's done it is an element of his claim, and certainly one would expect to hear evidence to the contrary if you're saying she's the only person that committed domestic violence. I mean, that would be the normal reaction. And there's a remedy for that. As soon as his wife tries to say he committed domestic violence too, you say, "Object, Your Honor, she didn't raise it in the pretrial statement." And my guess would be that if that happened, the judge would probably continue the trial and let people flesh it out. Because if I were the judge and you're talking about a little child, I'd want to know if there was mutual domestic violence or not. I'd want to know if the child was at risk.
So in your view, the pretrial statement was effectively amended by the evidence presented without objection here?
That would be correct, Your Honor. And I understand mothers. I'm not sure that I agree that it's good law. I do think that when parties try an issue by consent, and I think consent is when nobody objects, both sides present evidence about the topic and question about it, then I think it is waived. And I think there are an abundance of cases that say that. But I do think the fact that the courts are required to make these findings when somebody's alleged domestic violence, and I don't see that the law says that the courts only are permitted to make half the findings. And so I think if you look at the facts of this case, you know, you have this legion of cases that say you choose to represent yourself, then you're held to the standards of a lawyer. And so I could see mother's legal counsel at trial, it wasn't me, another lawyer, fine lawyer in Yuma, saying to the judge at some point in time, "Your Honor, I object. You've admonished husband 4 times already that he needs to use his time better and save his time and do all these things to manage his case. And I don't think it's fair to coach him how to try a case." Well, in the judge's November 1 minute entry denying in part and granting in part the motions for new trial, he set out 14 separate instances where he had coached husband about how to do his case. And I'm not complaining about it. I am not, I'm not saying, "Oh, this is awful, it should be reversed." I'm just saying the fact of the matter is husband has no room to complain. So even though he's held to a standard of a lawyer, here he had the trial judge, who was the person who was going to decide the facts, telling him what he needed to do to get his evidence before the court, and the husband choosing to ignore it. And although I respect the fact that counsel thinks that husband was unduly prejudiced by not having any more than 6 or 7 minutes at the end of the day of trial, I don't think he's bothered to take the time to count the number of times that husband asked improper questions and how much time he spent testifying as opposed to asking a question when he was supposed to be cross-examining or examining witnesses. And so I don't think that's wife's fault. It may be that there needs to be some kind of a different system here somewhere, but I don't know what that would be. But I certainly think that in terms of fairness, I mean, I've been to lots of cases with a pro se litigant on the other side where the judges gave them no coaching at all, nothing. And it's a disadvantage. And you can look at the distribution of property in this case. You know, husband had resources that he could have used to hire a lawyer if he wanted to. He's the one who chose not to. And one could say that the judge did him a service, in fact, by cutting the trial to 1 day. So a lawyer would only have to do a day of trial instead of doing a day and a half or 2 days. So I don't see that any of that is wife's fault, nor do I see that as being a reason to overturn anything. And I do think that Gunderson's November 1, 2018 minute entry, granting in part, denying in part the motions for new trial, is one of the more elucidating minute entries I've seen in my years of practice. And I think he's very clear in what he addresses, and I don't see a reason to overturn him on those issues. And
How about the attribution of income?
sure, happy to address that.
Husband, yeah.
So if you read the income worksheet for child support, on the earliest of them, I think there's 3, an A, B, and a C. The earliest of them, husband's attributed $11,500 and something a month, I think, for his income. That's before he lost his job. Because he has $2,400 a month in passive income. I think in my brief I mentioned he said it was $2,300, but it's actually $2,394 between his military retirement and his VA disability check. So he had that as income, and then he had $9,000 a month, which actually is more than that, really, if you count all the benefits the federal employees get. But $9,000 in salary and supplemental pay. And the judge attributed to him $4,600, roughly half of that. And they're saying that because husband lied to his employer, forged wife's signature on a TSP, a thrift savings plan withdrawal for $40,000, and because he lied to the police about what instigated the incident in, I think, October of 2014, he loses his job as a law enforcement officer because he did that, one or both of those things. It's not easy to tell from the testimony, but we've given you citations to that. But because he did that and loses his job, that it then somehow becomes wife's burden to show how much he can earn. And I would submit to you that's not the law. And I've cited your cases, Worth versus City of Flagstaff, cite some cases in it. I gave you that in the briefs. Something should be attributed to him plainly. I think you could say, well, the wife has the burden. She has to say she's going to attribute income. Well, I think it's academic.
Well, at the end of the day, regardless of who has the burden,
Yes.
the court's decision has to be based on something,
Yes.
doesn't it?
Yes.
So how do we get from a presumptive minimum wage to half of the prior income?
Well, you're talking about somebody who's been very well employed in his lifetime, Your Honor. And I personally think, this would be my view of it, I mean, husband lost his job through actions on his own part that he either knew or should have known would have caused him to lose his job. And so he gave away his $9,000 a month in income. And I don't see where it's then appropriate to say, well, let's attribute him minimum wage, as though he's just graduated from high school and never had a job before. He's had responsible positions. You can't do 20 years in the military without having a responsible position, because if you're not responsible, they kick you out. So I think that's academic. And then 10 years in the Border Patrol. Again, I think any job in this society where somebody issues you a firearm to do your job requires you to be a responsible person. They don't give those jobs to just anybody. I know that sometimes we think that cops, policemen do things that are dumb or whatever, and that's true. Everybody does something dumb at some point in time. But the fact of the matter is, if you don't have some measure of responsibility in what you do, you can't get those jobs carrying a gun. Now, you can if you're a civilian, because now they let anybody carry guns. But the fact of the matter is, the judge didn't have, I would say, evidence of what exactly husband can earn, and frankly, I don't think he could ever have it. How could he have it? Because all people can do is speculate about what his earnings are. And whose job is it to show that? To me, my view of the case would be, the judge said, well, you know what, Mr. Peralta, you're the person who caused yourself to lose your job making $9,000 a month, and I don't see why you can't make $9,000 a month. And if you can't make $9,000 a month, then you should come to me and show you why you can't earn that and what you've done to attain other employment. And I think that's his burden. And he did nothing to show that he couldn't earn. He just said he was going back to school, I think is what he said. And I don't see why the court has to be hampered and put mother to the burden of hiring employment experts to come up with some range of figures about what husband could do for a living. And do I think there isn't a lot of evidence? Yes, I do. But I think what there is, there's a lot of evidence about what his income actually was before he got himself fired. There's that. And that's at $9,000 a month, and that's undisputed. And I can appreciate the difficulty. You want to be fair to everybody and all that, but I'd be the first to say that I always find troubling these cases where somebody says I shouldn't have to pay child support, and mother should have to pay all the support for the child, or father should have to do it because I got myself fired and so I don't have any income anymore.
You just
Yes,
said it
ma'am.
was undisputed, and there's conflicting evidence in this record. His affidavit says he earned $9,306 a month in 2016, but in 2017 it says he earned $7,805 a month because of the reduction in that payment for supplemental income. So when we look at which one of those two figures the court should have used to half, the income. Why wouldn't it have been more accurate to go with the lower number?
Well, Your Honor, I think the reason that I would give is that I think it's very clear from the record in this case that the court didn't put much credence in what Mr. Peralta had to say. I mean, it's clear from the record that he had lied to law enforcement people.
I agree, but there are pay stubs that substantiate this amount.
It doesn't mean that it's permanent, does it, Your Honor? You didn't have
Pardon me?
anything to say was permanent. And then by the time they get to court, a few months later, all of a sudden, he's out of a job completely. So, because of what he did.
But counsel, these figures matter for purposes of the child support worksheets, and there, if I remember, there's a little bit complicated, but there's three different sets of worksheets.
Yes.
So don't these facts matter?
Well, the question, Your Honor, I think should be who should have the burden of showing that he can't earn. Well, all right, the $7,000, that doesn't include his $2,400 a month in passive income, his retirement pay. That's just what his Border Patrol income is. So I think $4,600 is still less than $7,000. The court still cut him slack. It doesn't offend me. I don't think it should offend the court. Part of the problem you have here with this.
But so wait, was the 4,600? Did that include the supplemental income?
No, I think that's what the court said he could earn over and above. I wouldn't call it.
Wait, I mean, when the court halved it. When
No.
the court cut it in half.
No.
That was gross pay.
I
mean, not gross
think
pay. That was
the court just took the figure of $4,600. I don't think but
You
it
don't
did.
know exactly.
It did think about the 40. It did say it considered the $2,600 a month in supplemental income, or $2,300, whatever it was. It says that in that November 1, 2018 minute entry that the court considered it. But I think the court ended up reducing the child support because of that. I think the court it didn't reduce that, or reduced in part. I think the order for attorney's fees. I don't know that it reduced the child support.
Let's talk about the equalization judgment.
Yes.
The court did not order any interest on the equalization judgment unless mother failed to pay on time.
Yes.
Doesn't that fly in the face of the requirement under Title 44, Section 1201B?
Do I have to answer that?
It behooves you to do so.
Well, I will candidly tell the court that this would be more concern to me if it was a big judgment. It's not like $26,000 or something. Even at 4 or 5%, 5%, you're talking about $1,300 a year if you don't pay anything on the principal. And to me, in this case, it's equitable because wife was awarded the house, and there was no set-off or anything, which is typical when you're awarding an asset. And if you're selling the house, you deduct selling expenses and all that. And so she's taken a hit of several $1,000s on the judgment itself because of that. If they'd done what husband asked and sold the house, then his loss would have been much greater than what you're talking about for this interest. And if interest was 10% like it used to be, it'd be a more significant thing, but I don't see this as being a big number, Your Honor. And I understand that the court could say, well, the court should give him interest. Although the court also did not say whether or not, if it did so, it could also order that payments be first attributed to principal. And at $400 a month, that's $4,800 a year. This thing's going to be paid off in about 4.5 or 5 years anyway. So you're talking about a very long time. It's not a big number. If I were a lawyer, I wouldn't argue about it just because the legal fees would far exceed the interest that you're talking about. But I don't disagree that under the statute, on liquidated sums, you're entitled to have interest at the legal rate. I don't disagree. That is the law. And I don't think I said otherwise in my answer. But that's...
All right, can we move on to the findings the court made regarding the unreasonable positions of father?
Yes.
Explain how the renewal of the lease comes into play when finding father's positions to be unreasonable.
Well, father's position was that that was a reasonable thing to do in the circumstances, when in point of fact, the law in Arizona is that if you're going to lease out jointly owned held property, then both parties ought to be signing the lease. There's also an automatic preliminary injunction in play that says that you're not allowed to transfer, conceal, encumber, dispose of any joint, common, or community property. And certainly when you put other people in the house that he knew that his wife wanted to get in the divorce and move into, and then 3 days before the trial, they extended the lease for another 6 months or a year, whatever it was, a length, frustrating that without talking to her about it. I mean, I briefed this in the answering brief, Your Honor.
Do you
Spite.
think the court found 4 separate things?
Yes.
And do you think any one of those things would justify that finding?
Yes, I do, Your Honor.
When we
And
talk about the 4th factor the court found, which is the subjective intent of father, is there any case law that supports that as a finding for unreasonableness?
I cited a case that says that with respect to things that are filed, you're supposed to look at the objective evidence of intent. But on the other hand, I think the trial record and the clerk's record in this case reflect an ongoing intent by father to be as mean and nasty and spiteful as he can possibly be in this case, Your Honor, which I think the judge was absolutely correct in saying that husband's approach to this case extrapolated because the proceedings to be more protracted and more expensive. And I think you can see the judge's reasonableness and discretion appropriately exercised when he granted in part father's motion on the new trial with respect to that, when he reduced the judgment for attorney's fees from $20,000 to $15,000. And so I think he was motivated by what ended up costing the parties. And I'll be the first to tell you, Your Honor, you look at the statute, and I think it's a mistake to say that you should only be basing it on what people file with the court. I don't think that's appropriate. I think one of the things that happens in these family law cases is that so much happens with the way that people behave while the case is pending. For example, one of the comments made by the court was in reference to a quote from the Barron case, where the court found that a party who doesn't facilitate more contact, even though they're complying literally with the terms of the temporary orders, can be found to have been unreasonable in their approach. And that's one of the findings that Judge Gunderson made in this case, one of his specific findings that was respect to the things that father did to frustrate mother's time with the child while the case was pending. And I would say that he couldn't do that as a basis for fees if this had all happened before anybody filed for divorce, because this is a no-fault state. Okay, but once the automatic preliminary injunction's in place and you do have court orders and that thing, I think that anything that you do that makes the case more expensive unreasonably, including those things found by Judge Gunderson, are appropriately considered under the statute for awarding fees in terms of reasonableness. May I answer any other questions for the court?
Thank you, counsel.
Thank you, Your Honor.
So I'll be brief. That's all the time I got. I think in your questions, you somewhat focused on the real problem in this case, which is if the trial judge was going to look at what we call mutual domestic violence, it needed to look at it. In this case, what the judge did is say, I'm finding mutual domestic violence, and so I'm not going to look at how domestic violence affects the best interest of the child. I think you're right. What the trial judge should have done is analyze which of the parties, their domestic violence was much more of a risk to the child, which one of them created more concerns about the best interest of the child. What the trial judge should have done is looked at who pulled a gun on somebody with the kids in the house. That's what should have been done. So I think your questions are just right. You don't just find mutual domestic violence, throw your hands up in the air and move on. You have to take it seriously, and that's what the trial judge didn't do in this case. Based on your questions, I think you've got a really good grasp of my attribution arguments, so I'm not going to spend a whole lot more time on that. But I think your questions about the fees are quite telling. The statute talks about positions taken in the litigation. The statute is not some sort of free-floating license for a trial judge to punish every act it thinks somebody did wrong while a divorce was pending. It talks about positions. If a party takes a position that runs up the fees, yes, you're entitled to consider that for purposes of a fee award under the statute. But for example, the lease renewal, that was 3 days before trial. There was no evidence, testimony, even indication that that had in any way increased any of the fees mother was charged in this case. So to use that as some sort of free-floating way to award mother a big chunk of fees dating way, way, way back beyond the 3 days before trial was improper. The other things the judge found that my client allegedly did that were unreasonable just weren't unreasonable. For example, my client wasn't flexible in allowing mother to come to the first day of preschool. Well, he couldn't. There was an order of protection. She couldn't be at preschool at the same time he was, so that can't be unreasonable. The other thing the judge found was unreasonable was that he took a position saying he ought to have sole legal decision-making and he ought to have primary parenting time. Well, guess what? The prior judge had ruled that's what should happen. So is my client now unreasonable for saying that what a judge held after considering the evidence was something my client shouldn't have even asked for? He's unreasonable in asking for it? That's not unreasonable. So this judge didn't like my client, it's clear. And he used the statute as a way to punish him for everything he did that the judge didn't like. It had nothing to do with the positions he took in the litigation or any way that they increased mother's fees. So I'm out of time. If you got any other questions, I got 20 seconds. I'm willing to hang around.
Excellent. In regard to letting the residence, it's claimed that mother wanted to live in that residence. Is that correct?
It is. What's important to note is mother made that argument at the temporary orders hearing in November of 2017. The trial court said no. And the lease was up. And the trial judge had said it could take me 60 days to rule. So my client's option was to let it sit vacant, and who's going to pay the mortgage for 60 days if he doesn't renew the lease? That was the testimony. So mother had indicated she wanted the house. The trial judge denied it at temporary orders, and we didn't know how soon the judge was going to rule, and we didn't know if the judge was going to grant it to her. So given that, it would have been, some would argue, community waste to just leave it sitting vacant if the judge was going to take 60 days to rule. So he had very little choice. He did what he had to do to protect both parties. It may not be what the judge wanted, but to find that it was unreasonable, I don't think so.
Thank you, counsel. We thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. We are at recess.